Welcome to the Binary Agora.
In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and real-world impact with insights from top researchers. And today, I'm really excited to welcome Professor Pablo Ibáñez Colomo. He's a full professor of law at LSE, an ordinary member at the UK's Competition Appeal Tribunal, and also a visiting professor at the College of Europe at Bruges. His work and research also spans all matters competition law, including the in-depth analysis of legal standards and also their transformation during these last few years. And in this sense, I would very much recommend his latest book, The New EU Competition Law, where he carefully considers the state of EU competition law as we know it now. So welcome to the Agora, Pablo.
Thank you very much.
To start off the conversation, Pablo, you have been researching and also figuring out extensively what each wave of competition policy represents for the broader corpus of EU competition law and how those criteria introduced both by the European Commission, the national competition authorities and the courts have crafted this discipline. And I guess that also this latest era, I would call it the digital era, also has elements and criteria of its own. And in fact, in your book, you term the DMA specifically as the expression and also the end game of the new competition law. So I would first ask you, how have we gotten here and whether we are placing ourselves into would say a competition policy cul-de-sac with the DMA that we can rarely escape from now?
That's a great question. I think a very helpful one to get us started in terms of the work that I do, but also in relation to the evolution of competition law. So as you're rightly saying, much of my interests as a researcher focuses on the strategic interaction of the various actors, and then say how the administrative authorities, such as the European Commission, engage with the courts, how the courts react to the work of administrative authorities, and then how the firms engage with the subject and how they position themselves in relation to the substantive and procedural aspect of the subject as well, right? This has been sort of consciously or unconsciously the focus of my work and the new EU competition law. Thank you for the kind words about it. By the way, I don't think it's an exception in that sense, right? So then the overall theme, as you were pointing out, is essentially this transformation that the discipline is undergoing and the emergence of this new EU competition law that we have been tracing over the past decade or so. So then what explains the emergence of this new EU competition? How do we get where we are now? The more I discuss this matter, and there's a good occasion as any other, the more I am inclined to present this transformation as sort of a particular point in a pendulum swing. What we have seen essentially over the past decade or so is the pendulum swinging in terms of priorities. At the two ends of the pendulum is essentially the choice between getting things right and getting things done. The more you focus on getting things right, that is to say, in avoiding enforcement errors, in making sure that you incorporate the best available expertise and so on, the more risk you run of not getting things done at the end of the day. And vice versa. So the more you focus on getting things done, the more likely it is that you are going to make mistakes. And so then say 15 to 20 years ago, the pendulum was decidedly swinging towards getting things right. And accuracy and sound economic analysis, etc., were the priorities. Now, I think we see the pendulum swinging towards getting things done. And the DMA, we can elaborate on that, is an expression of this change in priorities. The message of the DMA is essentially get things done and get as far as you can or faster and farther than you would otherwise through the enforcement of Articles 101 and 102. This is why I say that the DMA is the culmination of this swing in the pendulum towards getting things done. You get to the point where you say, well, competition law is no longer enough. Competition law is encumbered by these sort of substantive and procedural requirements, and this means that it's going to stand in the way. And on top of that, you cannot go after dominant positions as such. You have to establish an abuse. Let's get to a new sort of enforcement landscape where we can go farther and faster than you would under competition law. So that's essentially the trend, right? And then comes the key question that you make is how did we get here? My perception is that the calculus of some of these actors has decidedly changed. And I think that's the fundamental consideration to take into account. For a long time, and say 2 decades ago, it was in the interest of the key actors in the system to ensure that enforcement would get things right. It was in the interest of most firms, in particular, but not only dominant firms. So firms potentially subject to competition law and potentially benefiting from competition law enforcement, all of them sort of saw the point of cautious enforcement that would be informed by economic analysis. I want to make sure that competition law remains cautious and is informed by the best available expertise. If you're a dominant firm, well, even more so. And then all other undertakings, so expertise as benefiting them. The expertise would be a bulwark against lobbying by big actors. Things change significantly, right? So the calculus changed. It's very difficult to see why. Once you see the emergence of big tech, essentially transforming many sectors in the economy, from press, advertising, music streaming, then many actors in the system say, well, why don't we act more quickly and decisively through competition law? And then all of a sudden, getting things right was not so attractive anymore. You sort of wanted actions, faster action, and you were more tolerant of mistakes. And in these new landscapes, if we make enforcement errors, if we go too far, if we take action, even though anti-competitive effects are not so likely in the end, well, then so be it. It doesn't really matter. Errors are part of enforcement in any sort of institutional system that we set up. The calculus also changed, as far as I could see, and I discussed it in the book, from the perspective of competition authorities. This is where the discussion in the book about legitimacy is so central. Why did the European Commission and other major authorities embraced decisively economic analysis? Because it was a way to convey a perception of legitimacy vis-a-vis undertakings potentially subject to competition or enforcement, but also it was a signal to courts. Let's not lose sight of the picture that in 2002, the European Commission lost some cases before the General Court. And what underpinned those defeats before the General Court, Court of First Instance back in the day, was the perception that the European Commission was not basing its analysis on the best available expertise. And in a way, it was the signal, if you want enforcement to be credible vis-a-vis actors, but also enforcement to be credible vis-a-vis review courts, you have to embrace economic analysis. Otherwise, you're going to be subject to endless criticism. The perception is going to be that you're an outdated authority, that you're basically making up your expertise along the way. And this is going to mean that you're more vulnerable. Firms may be less willing to reach negotiated outcomes with you, but it also means that you're going to appear weaker before the courts. In that landscape, embracing economic analysis was also something that formed part of the calculus of competition authorities. As things moved on and as the expectations of the business community also changed, I think the importance of grounding your analysis in sort of the best available expertise was not so central anymore. It had to be balanced against other considerations. And this is why we see now, when we discuss the review of Article 102 enforcement, so then some economists are saying, well, where has economic analysis gone? Well, it hasn't gone anywhere as far as I could see. What we could notice from the efforts of the European Commission is that we need to make sure that the law remains administrable. And that has to be an important part of the picture, and getting things done and making sure that enforcement can alter things. This has to be another aspect and another element of the calculus. This is why I think we got from here. So it was simply a swinging of the pendulum from that perspective. And I think the metaphor I'm using with the pendulum, in a way, gives you an answer to another point, or is a counter argument in relation to another metaphor that you yourself use. You were referring to whether actually the DMA was getting us into a cul-de-sac. Then if you agree with my metaphor, you will see that there's no such thing as a cul-de-sac from this perspective. What might happen at some point is simply this pendulum will swing in the other direction. And there are many reasons already, and we can discuss that later in a more structured manner if you like, as to why the pendulum might swing back in another way. it's easy to see, given the institutional changes that we're witnessing in competition law. And what I have in mind in particular is the spectacular rise of private enforcement, why the pendulum might swing back, and why we say, well, actually focusing on getting things done means that the system might become unmanageable. An obsession with getting things right means that authorities are paralyzed and then nothing gets done. We all agree with that. But an obsession with getting things done, irrespective of any other considerations, then might actually lead us to an equally intolerable outcome. And private enforcement is likely to accelerate that trend. Right? If we're talking about cul-de-sacs, and I'm intrigued about your opinion in case you have something to say, is whether the DMA itself is putting itself into a cul-de-sac, right? So then if we consider the system as a whole, I don't think competition law will be forever stuck in this equilibrium. Things will change, and I think the moment we start realizing the downsides of obsession with getting things done, no matter what, the system will readjust and we will reach another equilibrium. But I'm more intrigued about the DMA itself as an instrument. Why do I say that? Because the DMA has no obvious way out. And I think you're the expert in the regime more than any other. But I think the one thing I'm intrigued by, and I think in particular when looking at the DMA in light of the EU telecommunications regime, is that it is very difficult to get regulation undone. And that's quite interesting. It is true that there are mechanisms for this to happen. But the one thing I would like to follow further down the line when it comes to the DMA is how expectations will be handled, in particular, given the fact that there's no clear bright line that is telling us regulation or intervention is no longer needed. When you look at telecommunications regulation, the bright line was very clear. We have to look on a regular basis whether the markets that have been selected are still dominated individually or collectively by one or more operators. You look at the picture, so the market is no longer dominated one by player, so the dominant position has been removed by virtue of the implementation of the regime. Then we roll back regulation. But there's no such clear bright line in the DMA. And that means, well, what is going to happen? Are we going to be stuck in forever regulation? Is fudge going to be found between the various actors in saying, we no longer believe that regulation is needed, so let's find a dignified way out for everybody involved? So if we're talking about cul-de-sac, I think this is the one question I'm really intrigued by looking into the future. Right? I think that's interesting as well as a discussion as to how things are changing. Going back to the theme of your question, right? Telecommunications was a well-understood market, but when the telecommunications regime was implemented in 2002, there was this faith in markets and in competition and innovation in addressing any potential concerns, right? The DMA is based on a different idea, right? No longer reflects this faith in competition and innovation. And that means that the legislature was much more reluctant to draw bright lines saying, well, we no longer need regulations. When it comes to cul-de-sac, as I say, this is the one issue to follow with interest in the coming.
Thank you so much, Pablo, for that extensive response, especially with your metaphor on the pendulum. And I would say that the shift or the movement of that pendulum from right to left, I would establish, especially with regards to this interplay between competition law and the DMA with the anti-steering practices. We brightly saw how the European Commission was really interested in ending with anti-steering practices posed on the music streaming market via Article 102 by reinterpreting the exploitative abuse theory of harm. Then 1 year later, the European Commission did again reinterpret its antitrust case to the DMA, and it brought another case against Apple, and it reframed the legal standard once again of those exploitative abuses under the lens of the DMA. I would place the movement of the pendulum just there. And going back to the point of the cul-de-sac, in my own view, the DMA does place itself within this cul-de-sac, especially with regards to the establishment of legal standards. although the enforcer is really, I would say, preoccupied in telling us those rules are really clear and straightforward to interpret and to apply in practice, but that's not really what's happening, for instance, in the compliance reports, nor with the complaints coming from all of the operators. And we are already seeing how the European Commission is reinterpreting both substantial rules coming from the DMA, but also procedural rules coming from the DMA. So, for instance, Meta's Article 5.2 case, we are seeing that the emphasis is not so much on the leveraging capacity to leverage that data, that personal data from its competitors for its own profit. We are talking about a different thing, which is specific choice. And the focus is not business users or competitors so much, but the end result of consumers. We are seeing a refurbishing of the existing theories of harm, and I have renamed it as theories of infringement. The European Commission is now building these theories of infringement. Going back to your point on the impacts of the DMA and how success is going to be determined in this regulatory setting, I would point to the greater fault of the DMA, which is not defining itself via the protection of competition, but instead by the enhancement or the wish to enhance contestability and fairness. But contestability and fairness defined in a different way, as introduced in recitals 32 and 33 of the DMA. In the case of contestability, eliminating barriers to entry and expansion, and fairness ending with imbalances of rights and obligations. We do not really know, first, what barriers to entry and expansion the legislator is talking about. We don't really know how that's going to be measured. And in terms of fairness, I would say that it's quite an elastic notion to really try to meter it against a given benchmark of. So we will rarely see the instance where the European Commission will say this is enough. I don't really see how the European Commission will say, without the backing of these legal standards and without the way in which to stop or to counter the expectations of the operators and the business users, how it's going to stop those. And going back to contestability, in your book, in fact, you also refer to this concept of contestability and also appropriability that the DMA introduces, so that it differs from competition law and also from intellectual property. So how would you say that these two elements interact, and also what would the economic outcomes, although the European Commission is not really worried about those on paper, that you anticipate the regulation to produce?
Thank you. No, that's a great point, and I think it's slightly nerdy, probably, so it might make sense that I say a word about what I mean by appropriability and contestability, and I think why they are relevant. These concepts of appropriability and contestability are not mine. They were used by Carl Shapiro in an article that I would recommend to all of your listeners. Carl Shapiro, in that article, was discussing the alleged conflict between competition and innovation, as if we have to balance them. There's some sort of tension between both. And I think the answer that he gives is the right one as far as I can see, which is to say that there's no essential conflict between competition and innovation. This is for several reasons. First of all, I think we all agree that long-run competition is the one that really matters. Competition that has innovation as a parameter is the one that is going to lead to long-term prosperity and to the benefit of citizens in reality. This is not to say that static competition is not important, but over the long run, this is what really matters. The other point he makes is that there's not really that much of a tension between static and dynamic competition. So this is an oversimplification at the very least. And this is where he introduces the concept and says, if you want magic to happen, and by magic I mean innovation and dynamic competition to happen, what you really need are these two elements. You need an element of appropriability, that is to say, if you come up with something new, you must be given the means for you to appropriate the fruits of your efforts. But you also need contestability. Third parties or other actors need to see the point of entering the market. If you're unable to appropriate the fruits of your efforts, what's the point of innovating? If others do not see an opportunity or don't come to believe that if they come up with something new, they will be able to enter the market, again, innovation will not happen. His conclusion was to say, you need appropriability and contestability, and you need to balance very carefully the two. I apply his framework in another context, which I think is a very obvious one in the book, which is the tension, or the alleged tension rather, between competition law and intellectual property. And so then the oversimplified picture is to say, well, intellectual property focuses on appropriability in giving sort of innovators, creators, the means to appropriate the fruits of their efforts, whereas competition law cares about contestability, cares about keeping markets open. Well, this is not really the case. Intellectual property cares about contestability as much as it does about appropriability, and that's very obvious if you think about patents. You're given protection against entry for 20 years, but after that, the market becomes fully contestable. If we look at competition law, the same is true. Competition law acknowledges and accepts how crucial appropriability is. McGill, IMS Health, all the refusal to deal doctrines are a very good example of that. I think it has been repeated in Slovak Telecom and more recently in Android Auto. But if you look at cases that deal with franchising and with other vertical restraints, you see how sensitive the court is to appropriability concerns. If we're going to formulate legal standards in competition law, we will have to acknowledge how important appropriability is, both for long-term and short-term competition. So that's the framework in which I use these concepts in the book. And the conclusion that I come to in chapter 4, which deals with competition law and intellectual property, is to say, well, there's not that much of a tension between both. Is that if there's a difference between competition law and intellectual property, it will relate more to the means that each of the systems use rather than the consideration of the two. Right? And then comes the DMA. It also balances appropriability and contestability, but does so in an innovative way. And I thought it might make sense to discuss that in the book, if only because I haven't seen that much of a discussion on that particular point in the literature. So if we take the example of intellectual property, I think the technique is quite crude, but it's straightforward. Think of patents. You're going to be given blanket protection for 20 years. The degree of protection that you get is going to depend on the contribution that you make to the state of the art. And after 20 years, the market will become contestable. When it comes to competition law, there's going to be case-by-case intervention, but it's going to be case-by-case intervention that is going to take into consideration the degree of innovation that you make. If you look at the McGill doctrine, for instance, that's a very good example. If you're dominant, you may be asked to license your intellectual property if the contribution made by the would-be entrant goes beyond something obvious, something that already exists. In other words, if the new entrant would come up with a new product. Right? These are different ways of balancing appropriability and contestability. Enter the Digital Markets Act. And they do something quite interesting from a number of perspectives, right? The degree of protection you're going to get is not going to depend on how much you innovate. It's not going to depend on how much the would-be entrant is going to innovate, but it's going to depend rather on the degree of economic power that you have. And I think that is quite interesting. The degree of appropriability, or rather the extent to which gatekeepers can appropriate the fruits of their efforts, is going to be brought down by virtue of Articles 5, 6, 7 of the DMA. By contrast, the ability of business users to appropriate the fruits of their efforts is going to be increased by virtue of the DMA. Right? The degree of protection that you get under the DMA no longer depends on how much you innovate, on how worthy of protection your products and services are, but rather the degree of economic power that you have. One example, for instance, is Article 6 concerning search engines. While you're powerful, then the extent to which you can appropriate the data related to the searches is going to be brought down. By contrast, a business user is going to be able to appropriate more than it would otherwise in other legal contexts, right? So this balancing actually, and this criterion of economic power as deciding how much you can appropriate the fruits of your efforts is a really interesting innovation in the DMA. This goes hand in hand with, I think, is the central consideration of the DMA. Beneath those concepts that you were mentioning before, fairness and contestability, what underpins the DMA at the end of the day is redistribution, either by opening up markets or either by crude price fixing. We're going to redistribute in a number of ways by limiting, for instance, how much gatekeepers can charge, but also how much they can appropriate the fruits of their efforts.
In the spirit of redistribution, I was wondering, where would we place the success of that redistribution? So are we aiming at, for instance, given the possibility to a business user to become a gatekeeper, that's the objective of the DMA, or are we trying to lower everyone's bigness?
That's a good question, and we have a clear answer. I don't think the DMA intends to go as far as to make everyone a gatekeeper, but I think it has this sort of decentralization concern, and I think making or reducing the extent to which gatekeepers can appropriate, I think is a very good expression of that, right? Probably we look at the structure and sort of the history of the legislation. Let's make sure that there's no gatekeeper either way. Whether that can be realized, that's a completely different question. And this takes us back to the cul-de-sac. But let me go to the other point that you raised, which was what is going to be the economic impact of that? I think I would distrust anyone who can give a confident answer to that, because I think there's a lot that we know, and I think there's always this tendency of some scholars to say we don't know anything about the relationship between competition and innovation. I would say we know quite a bit about the relationship between competition and innovation, but we don't know enough to make any confident predictions. What we can say is something else. We cannot claim with any confidence that more contestable markets are necessarily going to give rise to more innovation. And this is a mistake that I sometimes see made when discussing about the DMA. The DMA might be good for innovation, might be bad for innovation. Policy cannot be based on the premise that by making markets more contestable across the board, you're not going to necessarily increase innovation. I think that's a lesson born by history. As someone who got into competition law in the mid-noughties, I've seen quite a bit of trends. But we can say with some confidence that sometimes relatively closed or outright closed systems can bring about a great deal of innovation, but also the opposite is true. Those who plead in favor of more contestability will say, let's look at the internet as an open system. I think that's absolutely right. Then you could say, let's look at closed systems. One of them would be Apple, a very curated ecosystem made the smartphone revolution possible. Some people might say Apple's was not the first smartphone, to which I say that's true. But I think the smartphone revolution, as we know it, came with a product that was fairly closed. The point to make here is that magic can happen under any system, under any degree of openness. And I would distrust anyone saying emphatically that one or the other is going to bring about more or less innovations.
If we take actually the example that you just gave on Article 611, we are not going to see innovation in application of these provisions, specifically because some of the provisions are also crafted and fine-tuned to the extent that no other business model or monetization strategy is apt for business users, such as building those search engines from data in that sense. So that's where we place that dichotomy between the contestability and the innovation aspects of the DMA. And going back to this pendulum and to competition law again, so would you say that there's going to be an influence or a replacement of some of the legal standards that are going to be applied in EU competition law, in the European Commission's constitutional practice, in applying those articles 101 and 102 also as a consequence of the DMA's introduction? Or do you believe that there's going to be space for everyone and those two instruments are going to be quite differentiated in terms of their objectives and also in terms of their substance?
In terms of, is there going to be place for everyone? There definitely is going to be place for everyone. If there's one lesson that we take from past enforcement, that there's no reason to believe that things are going to change, there's rather reasons to believe that things are going to continue as they used to in the past, is that competition law is going to play a fundamental role moving forward in digital markets. And this is so for several reasons. One reason has to do with the Court of Justice attitude vis-a-vis the relationship between competition and regulation. So if we look all the way back to Deutsche Telekom from 2010, TeliaSonera, Slovak Telekom, the substantive choices made by the court have always gone in the same direction. Let's ensure that competition law has a prominent role to play in regulated sectors. That's one key lesson that one can draw emphatically from Android Auto. Again, the message is the same. we're going to tweak the standards, or we tweak the scope of application of Brunner and McGill to make sure that competition law plays a fundamental central role in digital markets. Right? The tweak in the Brunner and McGill standards was there to make sure that the indispensability condition would not stand in the way of meaningful enforcement of Article 102. So that's one aspect of the picture. That's very clear. So the message of the court has been consistent across decades. This is radically different from the one message of the US Supreme Court in Trinco. So then that's one element of the picture that makes us conclude that competition law is going to play a fundamental role. The second aspect is from the perspective of the European Commission, we can see the advantages of the enforcement of competition law for a number of reasons, right? For strategic reasons, sometimes it might make sense to enforce Article 102. And I think that in several respects, the landscape that has been created by virtue of the DMA means that Article 102 enforcement is going to be convenient or expedient from the perspective of the European Commission, right? We have the Amazon case as an example of that, right? One question that I think is open, I think we've seen some answers now. How much does the Commission want to clarify the legal standards of the DMA? Is one question you raised. The other thing, and one can see many reasons why the Commission might want to keep some ambiguity about the legal standards in the DMA. I can see an interest in that. And if that's the case, and if you want to keep some sort of ambiguity of the precise scope and nature of the legal standards in the DMA, it might be in your interest to close some proceedings with commitments under Article 102. Right? From that perspective, I think the role of competition law is going to be there. Another point we've realized over and over, and I think is going to become also dramatically apparent further down the line, is that gaps very frequently emerge in regulatory regimes, even though you have some built-in flexibility, even though the DMA is fairly exhaustive to the extent that you have stuff that you cannot foresee, but falls within the zone of a regulated regime, you will always have competition law coming to the rescue. This is not going to change. I think the signal is that's going to be room for everyone. Another factor to consider that, and again, Android Auto would provide a good example, is that after all, the European Commission is the enforcer of the DMA, and then this leaves national authorities with the possibility of relying on Article 102 in particular, but also Article 101 every now and then, to engage in sort of DMA-like enforcement. And if you look at Android Auto, you see how DMA-like it is, right? How essentially all the section devoted to objective justification amounts to the creation of mini DMA within the objective justification element of the analysis under Article 102. All of this is pleading in favor of the coexistence of Article 102, the DMA. Having said that, my impression is that enforcement of Article 102 is going to change. This is one of the elements that I discuss in the book. One of the consequences of enforcement alongside a regime regulating a sector is that essentially you see the phenomenon of blending emerging. At some point, the frontiers between competition law and regulation become blurred. There's no such thing as a pure competition law, and there's no such thing as an eternal set of objectives and substantive standards that are going to apply irrespective of the context. In chapter 6 in the book, I discuss the application of competition law alongside sector-specific regulation in telecommunications, energy, and we see the same things emerging in digital. Android Auto provides another very good example of that. So then I am struck, the more I read the judgment, how DMA-like is that judgment. How much the spirit of redistribution, the spirit of decentralizing power forms the judgment. And I think that's a very good example of that. So then the one key consequence of Android Auto is that now under Article 102, the design of products and the design of systems is not going to be within the gift of the dominant undertaking, right? We're going to move from product design to product co-design. The court is quite explicit on that point. When you redesign a product following the request of access, you have to take into account the demands and the expectations of the third party requesting access. If that's not DMA-like, I don't know what is. And this is the new landscape, right? We see this element of blending between competition law and regulation. As probably some laws of physics would dictate this sort of cross-fertilization between one and the other is going to become an element. There's probably room for everyone, but no longer competition law is going to remain pure. And by the same token, we're likely to see some element of fragmentation. One of the points I make in the book is perhaps we were going to see slowly the emergence of some sort of sector-specific competition law. Whether this is made explicit or whether this remains implicit, the sort of cross-fertilization with other regulatory regimes might mean that the substantive standards under Article 102 and to some extent Article 101 are going to depend or change depending on the sector to which it applies, right? Which is natural, if you ask me.
By that time, I'll say that you'll have to write a new competition law 2.0 to illustrate all of these changes, explicit or implicit. And thank you so much for visiting the Agora, Pablo, and also for contributing all of your wisdom on competition law and all things chilling. And that's a wrap for this episode. And if you have any thoughts or any feedback, just drop a comment below.
Thank you so much, Alba. It's been an absolute pleasure.